Hello everyone, and welcome to this very quick overview of Bulletin 129. There are a few interesting cases. The first, Blumke and Campbell, which was an appeal against a statutory will that had been ordered, and the appellant obviously was not happy with the terms of it. Her appeal failed because the Court of Appeal was of the view that she had not produced any evidence of how it was disadvantageous to her, even though she alleged that it was potentially quite disadvantageous, and also commented that no alternate will had been suggested in the proceedings. It's interesting reading to show what the Court of Appeal would expect if there's going to be a likely successful appeal against a statutory will. The other case involved a testator who had written on a copy of her will with a series of remarks, things like X no longer needs this, and I've already given this to Y. In another case, something for X and something for Y. And in the event, a number of the comments made that had been written on the will were found to be a codicil, obviously approved by the court under Section 18, the informal will provisions, and some of them were clearly just purely dispositive, not dispositive, they were clearly and purely just deliberative and therefore had no effect. So it was an interesting way that this person had gone about modifying the terms of her will and putting her thoughts on paper as well, but didn't obviously return to what specifically she wanted to do for the people that she'd mentioned that she wanted to give something to. The other case worth a quick comment is a war between two executors about the funeral arrangements. When I say a war, it was one-sided in the sense that the plaintiff went to the court asking for provision for an order that the funeral arrangements be X, and ultimately was visited with the indemnity costs of the other executor, and the reason was simply that there'd been no effort to reach a compromise or communicate with her co-executor, and I think it's salutary to that point, namely that where there are these disputes, in fact any dispute as we'd all appreciate, some effort to work out a solution before running off to court is always desirable. Finally, I just mentioned that we have new enduring powers of attorney and advance health directive forms coming into force on the 30th of November. I'm sure you're aware of that, but just thought I'd mention it in the bulletin so that you were reminded of those changes. Thank you.